Look, picture this for a second. It's exactly 2 weeks after the funeral. You're exhausted, you're grieving, and suddenly your phone rings. It's a very polite, incredibly professional voice on the other end. First, they express their deepest condolences, but then they casually inform you that your mother owed $18,000 on a credit card. And before you even have a chance to wrap your head around that massive number, the caller asks the one question they have been specifically trained to ask.
When can we expect payment? It sounds so polite, doesn't it? But it is absolutely chilling. And you know what most people do in that exact moment? They panic. They apologize. And in so many cases, whether it's out of guilt, confusion, or honestly just a desperate desire to make the phone stop ringing, they actually start making payments. Payments they were never legally required to make, not one single dollar of it.
Because here's the thing, that phone call, it is built entirely on something the collector is banking on you not knowing. So today, we're going to fix that. Think of this explainer as your secret legal playbook. We're going to decode exactly what happens to debt when a person dies, what actually gets paid, what gets completely erased, and the 4 very specific legal traps where a deceased person's debt genuinely does become yours. You're definitely going to want to stick around for the end too, because one of those exceptions quietly catches people in 9 specific states. And I mean, literally nobody sees it coming. Oh, and real quick before we jump in, this is purely education to empower you, not legal advice, mostly because laws can get a bit quirky from state to state.
All right, Section 1, the one golden rule. Okay, let's dive right into this. To understand literally anything else about this topic, we have to start with the fundamental rule that changes the entire game. The golden rule is this: when you die, your debt does not transfer to your family. It transfers to your estate. Now, what exactly is an estate? Well, your estate is simply everything you owned the exact moment you died. The house, the car, the bank accounts, even that weird old recliner in the living room nobody really wants. I want you to think of the estate like a brand new bank account that opens the very day you die. It has only one job: pay the bills and then close forever. But here is the absolute most important part. That account has a physical floor. When the money runs out, it runs out. Creditors don't just get to reach past that floor and start pulling money directly from your children's paychecks. Your son does not inherit your Visa bill. Your daughter doesn't inherit your medical debt. Normally, they inherit nothing but the paperwork. So why did that debt collector sound so incredibly confident on the phone earlier? It's simple. Because you are not legally required to pay and we are not allowed to ask are 2 completely different things in the eyes of the law. And the debt collector, they make their living right in that gap. Moving on to Section 2, inside the probate machine.
So what actually happens to that estate account we just talked about? Well, the legal machine that empties it out is called probate. A court appoints someone, usually named in the will, called the executor. And listen to this because it's a huge misconception. The executor's job is not to protect the grieving family from creditors. Nope. Their job is to follow a very strict, legally mandated order of operations. And this perfectly illustrates the pecking order of that machine. Let's look at how this works in most states. First in line, the cost of running the estate itself, stuff like court fees and the attorney. Second, funeral and burial expenses. Third, taxes, federal and state, because, let's be real, the IRS never goes to the back of the line. Fourth, secured debts. That means debts tied to a specific physical thing, like a mortgage or a car loan. And fifth, sitting at the very bottom, dead last in line, unsecured debt. Credit cards, personal loans, medical bills. Notice exactly where the credit card sits. By the time the line finally reaches it, there is frequently absolutely nothing left in the estate. When that happens, the estate is officially declared insolvent. And those unsecured creditors, they get zero. Not a payment plan, not a reduced settlement, zero. The debt is written off and it literally dies with the person who owed it. And you know what? The collector calling you totally knows this. They know unsecured debt is at the bottom of the barrel. They know the estate might be completely empty, but they're calling you anyway because they know that a certain percentage of grieving families will just open up their wallets out of guilt or simply because they don't know about that golden rule.
Let's get into Section 3, 4 ways debt transfers.
Okay, we need to move into some dangerous territory now. Remember those exceptions I mentioned earlier? The specific situations where a deceased person's debt genuinely does become your personal problem? Let's walk through the 4 legal ways debt actually transfers. Exception number 1 is the most common way debt follows a family. You co-signed. If you signed that loan, the legal reality is that you are not just a relative of the borrower, you are a full borrower yourself. Full stop. The passing of the other person changes absolutely nothing about your direct legal obligation to pay back that money.
Now, exception 2 is about joint accounts, and what's wild is almost nobody knows the distinction here. Notice the enormous difference between an authorized user and a joint account holder. An authorized user is just someone who is handed a piece of plastic to use, go buy groceries, whatever. When the primary account holder dies, that authorized user generally owes nothing. But a joint account holder, they actually signed the original application, meaning they share full liability. Think about that. It's the exact same piece of plastic, the exact same account number, but two completely opposite legal outcomes.
Exception 3 is that massive trap we talked about right at the start: community property states. If you happen to live in Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, or Wisconsin, buckle up. Most debt taken on during a marriage in these states is treated as belonging to both spouses, period. And this is true regardless of whose name is actually on the paperwork. So a surviving spouse in Texas, for example, can suddenly be legally responsible for a secret credit card they never touched, never signed for, and honestly never even knew existed. Now, every state has its own little nuances, but the core principle is that marriage in these 9 states can absolutely make their debt your debt.
And exception 4, man, this one is quiet, but it is brutal: executor errors. If you are the executor managing the estate and you decide to distribute money to the heirs before paying off creditors who had a valid legal claim, you can actually be held personally liable for the difference. Think about that. You didn't inherit the debt. You literally created it for yourself by paying the wrong people first. The big takeaway here, for sure, if you are ever an executor dealing with real debt, pay a lawyer to guide you before you hand out a single dime to anyone else.
All right, Section 4. What happens to each debt? We're going to move into a bit of a lightning round now, because not all debt behaves the exact same way when someone passes away. Let's look at exactly what happens going debt by debt. First up, credit cards. Like we saw, they are unsecured, dead last in line, and frequently written off entirely. Next, mortgage and car loans. The debt stays attached to the physical property, not the person. And there's actually a genuinely underrated federal protection here called the Garance-Germain Act. Sounds fancy, but it basically means when a relative inherits a home, the bank generally cannot demand the entire mortgage balance all at once just because the original owner died. The heir can just step in, keep making the regular monthly payments, and keep the house. For student loans, federal direct loans are discharged at death. Poof, gone. Erase the second you show a death certificate. Private student loans are a bit trickier, but federal law now requires something called cosigner release on death for loans made after November 2018, which is a massive protection. For medical debt, it's paid by the estate, but, and this is a big but, watch out for Medicaid estate recovery. If the deceased received long-term care paid by Medicaid, the state can actually file a legal claim against the estate to recover those costs. But look at that very last item we have: life insurance and retirement accounts with a named beneficiary. These are incredibly powerful. Why? Because they typically skip the probate machine entirely. The money goes straight to the person named on the document, bypassing the reach of the deceased's creditors completely. Having a named beneficiary is truly one of the most powerful financial shields out there. Our source material makes this super clear. The exceptions are incredibly specific, and knowing the exact legal standing of a debt is hands down your greatest shield against aggressive collections.
Section 5. Stopping the debt collectors. So let's bring the whole narrative right back to that opening phone call. Under federal law, specifically the Fair Debt Collection Practices Act, a collector is absolutely allowed to contact the executor to discuss paying the debt from the estate. That's perfectly legal. But what they are absolutely forbidden from doing is misleading you about who owes it. They cannot tell you that you are personally responsible when you aren't. They can't even imply it. They can't try to guilt trip you by suggesting a good son or daughter would just settle the account. So here is your superpower. If they call, you read this exact sentence: I am not the executor of the estate, I am not personally liable for this debt, and I'm requesting that you send all further communication in writing. And then you stop talking entirely. Zip it. Shut it down. Nothing good happens for you after you say that sentence.
Let's wrap up with Section 6, First 30 Days Checklist. Okay, we've covered the rules, we know the traps, and we have the script. Now, here's your actionable, step-by-step defense plan to build a legal fortress immediately after a loss. This is exactly what you do in the first 30 days. Step 1. Do not pay a single dollar of a dead person's debt out of your own pocket until you are absolutely 100% certain you are legally obligated to. Once you voluntarily pay even a little bit, you make it much, much harder to argue later that you never actually owed it. Step 2. Get official death certificates sent to every single lender in writing. And Step 3. Pull a credit report for the deceased and freeze it immediately. Sadly, and this is super grim, identity theft against the recently deceased is a very real, very ugly industry, and you need to lock that down fast. You see, the entire debt collection industry is designed from the ground up to make debt feel completely permanent and inescapable. But legally, it just isn't. It has a floor, it has a line, and for most unsecured debt, it has an absolute ending. You just have to know your rights to actually enforce that ending.
Now, going through all this brings up a really related question, one that surprises almost everyone once they realize these collectors are just using pressure tactics. Wait, can a debt collector actually sue you? And if they do cross that line, what happens step by step? Well, that is a fascinating process, and it's exactly what we're going to unpack in our next explainer. Until then, stay focused, stay informed, and I'll see you next time.